you of how trademark is filed and what is the procedure over there, so that we can move ahead and we can have a better understanding how the litigation works when the matter is filed in the court. So what happens is that there is a particular trademark. Let's assume there is a trademark called Royal, and it is for rice, right? Your product is rice. So we want to register it, and we would be filing an application before the trademark registry. Now it is done online as well as physically, and when e-filing is done, some discount is given, right? Now we proceed further. Now, one of the most important thing to keep in mind is, before advising your client about what trademark he or she should make or get it registered, it's duty of a trademark attorney to do a trademark search. The same can be done online, and the website, that is ipindia.nic.in, one can go over there and do a general trademark search. Now what happens is that in that trademark search report, list of many trademarks would come up. Now this is a list of the trademarks which would look, sound, in appearance, and have a similarity with your trademark. And the same is with respect to the product or service which you are offering. As I have already said, that I have taken a case of that we are filing a trademark for product rice, and our trademark is Royal, and that too, let's assume it's a word mark. Now word mark is a type of trademark. Word mark means a particular word is written in a different and a distinctive style, color, and its outward appearance has a particular uniqueness to it, so it can be differentiated with other marks, right? So as a trademark attorney, if you see that the similarity is too uncanny, or the degree of similarity is too high, so one must advise his or her client that please change your trademark, or please come up with a different trademark, change its outer appearance or so. Because what happens is that if at this stage correct advice is not given to a particular client, then it may also happen that it can go unnoticed by the examiner of trademarks, and he or she may get it registered. Now your client is looking at a very financially straining litigation then in future, because at the first stage itself, we as trademark attorneys did not take care of this fact that we should have done a proper trademark search. Right. Now moving further, a trademark application is filed now. Now for an examiner, it may take about 1 to 2 months to examine your trademark. Now what does this examiner do is that he or she may look whether this trademark is already existing, whether it's a copy of an already registered trademark, in which class it is to be registered, for what services it is to be registered. These are participants, please mute yourselves, please. Thank you. Moving forward, now this all will be taken care by the examiner of the trademarks. Now the examination report comes up before you, and if it's written that your trademark is accepted in absolute form, that means that the examiner does not suggest any change to your trademark or does not put any condition upon registration of your trademark, then your trademark moves ahead, your file moves ahead. In a case where certain conditions are attached to your application, such as, let's take this example only, that we were filing for a wordmark Royal and the product is rice, right? So now Royal is a very common word. Anyone can just take this word Royal and make small or big alterations to how it looks and how it appears to consumers out there with respect to its packaging, with respect to its boxes, with respect to the advertisements, and with respect to its viewership. So the examiner may suggest that please, these are these conditions, and if you fulfill these conditions, then I may move ahead, and it will become easier for you to register your trademark. Now, in another scenario, trademark examiner can also put objections on your file. Now, objections are put by trademark examiner in that scenario where your trademark is quite similar to other trademarks. The similarity is such that the color scheme, the color combination is similar, and the similarity has to be quite high. That is what is seen by the examiner. So he sends a notice to the attorney that please fix this issue, and it should not be that much similar to an already existing registered trademark. Now, in this case, what happens is that it's not necessary that a trademark is registered before the trademark registry. It may be an application which is pending also. Now, time of 30 days is given to remove these objections. One more thing I would like to add on is that the trademark rules which are annexed to Trademark Act 1999 are quite strict in nature. So one cannot just go and flout the time period given in them. If it's 30 days, then it means 30 days. If not, if you flout these rules, then you have to file again a fresh application to apply for trademark. Now, once your application has moved from this stage also, it gets published in the Trademark Journal. Now, what is a Trademark Journal? It is a list of trademarks which are yet to be registered and which are yet to be given a green signal by examiner of the trademarks. Once your trademark with its logo gets registered in the Journal of Trademarks, it's open, it's in public domain now. And 4 months time is given to all of you. I mean everyone, whoever needs to object to it and whoever needs to file an opposition to it. What happens is that sometimes already a trademark application is pending with a similar name or a similar appearance or a similar logo, that too in a similar class of services. And it gets unnoticed by examiner of the trademark. So this opportunity or window is given to people that if they feel that their trademark is being copied or has already been copied and now it is in the journal, so they can file opposition application to remove it from the publication journal. Now, once, let's suppose there was no opposition from anyone, your trademark is quite unique and the services which you're offering are also unique in themselves, and the word or the logo which you have associated with your services is quite distinct in nature. Now it gets registered. Now coming to the main part, after having the trademark registration certificate, now what happens is that in big commercial organizations or big conglomerates, there is always a competition, and one can find that the trademark infringement or copying is going on at a very large scale, and that too in products which are food items such as cooking oil, etc. They can be grains, cereal, and the infringement is taking at a very, very large scale. Infringement as well as counterfeiting, right? So now we begin with our civil suit, which we will file in the court of law. Now, there are two remedies which we may ask before the court of law. One is civil in nature and one is criminal in nature. However, here, due to paucity of time, and we have to restrict, I have to restrict my speaking to the given time period. I would be speaking about the civil suit or the civil remedy which is available. Now here, the procedural aspect of Civil Procedure Code as well as Commercial Codes Act 2015 comes into play. One has to keep in mind, one who's a trademark litigation lawyer has to absolutely keep in mind that while filing a petition for infringement of trademark, he or she needs to see what is the jurisdiction. Now, the question of jurisdiction is already given in section 20 of Civil Procedure Code, which says that where a person is personally working for gain, is carrying on business, and so on. Similarly, the same conjunctive provision is given in Trademarks Act under section 134, and it has to be read with consonance with Civil Procedure Code. Now, once your jurisdiction is made and you have decided that yes, my office is here or I'm working from here, so you'll start drafting your petition. Now, there are some of the things which need to be kept in mind while drafting this infringement petition. One must mention, I repeat, one must mention everything in pleadings. That is, there has to be a background story to your infringement petition. You must explain that since how long you have been using a particular trademark which is registered. Now, I would like to clarify one thing, that an infringement suit can only be instituted if a trademark is registered as per the statutory provisions given already. However, more recently, a judgment of Honorable Supreme Court was given in which it was held that even if there is a trademark, a person is having a trademark, I will again assume that it is royal. Fine, we have a trademark called royal and we have been using it and doing business in it since the past 20 years. And I have all the proofs. Now, what will these proofs be? These proofs would be your bills, your commercial transactions, your order receipts that you received from various vendors during this past 20 years. Sometimes what happens is that we lawyers also annex income tax returns to show our prior use, and that we have been using this trademark royal since the past 20 years or so to make our case more genuine and more strong. Now, coming back to the Supreme Court judgment, which I was stating, that what it stated was that even if a person is having a trademark and he is not the registered owner, that means that your application is still pending before the trademark registry, or you have not yet applied for the trademarks registration, or somehow it got rejected by the trademark registry itself and you did not appeal or challenge its order before Intellectual Property Appellate Board. So in case if you have sufficient proofs to show that you are a prior user, even though you are not a registered user, then you may proceed with an infringement suit. And that is what you should advise to your clients also, if they have cogent proof, that is bills or order receipts, to show their use since a very long time. Now, when I say prior use, this needs to be a continuous use. It should not mean that in 2010, I had a huge business regarding the trademark royal. I was supplying bags and bags of rice, pan India, right? And in 2012 or so, I just stopped doing business. And furthermore, after 2 years, I again began doing business in the same trademark. No, it should not happen this way. The use has to be continuous. It has to be prior along with it. It needs to be continuous also. Now, coming back to the point about the stage when we are filing our case, that is the petition for infringement of trademark. While drafting the petition, we must also include that how and when we came to know that the infringement has taken place, at what time period we came to know. Now, what happens is, and as a litigation lawyer, when we draft this petition, our clients themselves tell us that, ma'am, we have sent our own person in the market and he even bought those infringing or copied materials. Like in our case, we have rice, and one of my agent or my employee goes on in the market and he buys a similar looking rice bag, which has my trademark on it, right? So we have the proof from there also, and this needs to be mentioned very clearly in the pleadings, because from here only your cause of action will arise. You need to show that there has been infringement on face of it, and it's happening generally, it's happening at a large scale, and in that market itself where you are doing your business. Now, apart from this, as a litigating trademark lawyer or intellectual property lawyer, one needs to keep in mind that all of your annexures, now what are these annexures? These are documents which are to be annexed at back of your petition, which are in simpler words, the proofs, which show that the trademark belongs to you. Now, this may include your registration certificate, if you have it, your legal proceeding certificate, which has been made mandatory by Honorable Delhi High Court in one of its judgment. It's a recent judgment which states that a legal proceeding certificates has to be there before filing of the case. And in a case where the petitioner, who is your client in this case, has not yet received the legal proceeding certificate but has applied, then it's okay. At a later stage, he can file it in the court's record, in the court's judicial record. And for the time being, the registration certificate would be a good compliance of that judgment. Now, we have a registration certificate, and if we have a legal proceeding certificate, well and good. We will annex our status report. I do not know if you participants know how a status report looks like. It can be generated online. What one does is that you have to write the application number of the trademark in the given slot in the website which I have mentioned earlier, and you have to write the class of the product or services which you are providing, and then a status report gets generated. In it, it's written that since how long the trademark was being used, and where is the proprietor situated as of now, and so on, and whether there is any condition attached to the usage of trademark or not. So this needs to be annexed. Now, apart from the bills I mentioned earlier, the bills, the order receipts have to be mentioned. Now, why is it so? To have a strong case for your client, you need to show, and further at the trial stage, you need to prove that you are or were a prior user. Second, you have honestly adopted the trademark. You are the honest adopter. Maybe sometimes it happens that your trademark might also have some, few similarities with the other existing registered trademarks. But you were the honest adopter. And regarding that, you need to give a background story. That how come this trademark came into being. If your trademark is royal, how come it came into picture. Like in one of our cases, it happened that our client was having a partnership firm by the same name. So he sort of was inspired by that name itself and he used that word in its trademark. Now moving on further, we all have to prove these few things. Now you have mentioned these in your petition that you have annexed the documents which were required. Now your case gets admitted. Now the first stage is that there are arguments on admission. Now what is happening here is that there needs to be a compliance of Commercial Codes Act also. There are few of the provision which needs to be taken care of according to the Commercial Codes Act. What happened is that when the Commercial Codes Act came into force, there is this provision which is section 2 clause C of the same act, which has included all the suits relating to infringement of trademark, copyright, and so on to come under the ambit of Commercial Codes Act. Hence, now they are commercial suits and they would be dictated by the provisions of Commercial Codes Act, which is a supplementary law to Civil Procedure Code. It is a procedural law, not a substantive one. Now, one of the most important requirement is that one must file the list of documents according to the format or the table which is already given in Commercial Codes Act. The table is given at the back of the Commercial Codes Act. If some of you want to pursue intellectual property rights litigation, one must have a look so as to enhance your own knowledge and your own practical experience. It has some columns which need to be filled and it needs to be done exactly in consonance with the provision of the Commercial Codes Act. Fine. After this list of documents is prepared, now you have all the documents are attached. Apart from this, a very, very vital application needs to be filed if the infringement is taking on at a large scale, it is hampering your business, it is financially causing losses to you and your business, or you're a very big rice mill owner, right? You are even producing rice, packaging it, processing it, further selling it into markets. You have various vendors and units which are working on behalf of you to make your business go and go in markets. Let's suppose it is a pan-India project. Now, as a litigating lawyer, you will advise your clients that we will also make an application for temporary injunction. Now, what happens is that if the infringement is urgent in nature, now let's suppose someone is copying your trademark Royal and you are producing rice, you are packaging it and processing it. Now, rice is a food. It is something which is a consumable commodity. So, it's quite risky that a package bearing your trademark is being circulated in the market by other few people claiming that it's your trademark. And now that rice is not of superior quality. It may even cause ill health or diseases or other health complications in a person when consumed. So it's quite urgent and it becomes very necessary to tackle that issue. For that, as a litigating lawyer, you can also file an application for grant of ex parte injunction. That means ex parte would mean that the defendant in this case has not been summoned as of now, but the honorable judge, honorable court takes cognizance of the fact that infringement is so great so severe in nature that it will, apart from hampering and adversely affecting your business and your revenue, it is also affecting adversely the consumers out there, because it is a commodity which is to be consumed, right? So the Honorable Court, what it does is, it may grant you an ex parte injunction, and it may direct you to even go for appointment of a local commissioner. And it may also further give you instructions that on the similar day itself, please file an application for appointment of local commissioner, and on the same day, I will order for ex parte interim injunction. Right. Now, the purpose of appointing a local commission, as given in Civil Procedure Code, we call it as appointment of local commissioner, is so that that local commissioner within a week or within a span of 10 days from his appointment goes to the premises or to the place or to a godown or to a storehouse, warehouse of the defendant who is storing your rice bags and has a similar misrepresenting trademark of which you are the genuine owner or a registered owner, but he is not. And he is selling those bags claiming that that is of your brand. And hence the rice is of superior quality and it's need to be sold. So the local commissioner, along with some of the police officials, it's written in the order that the local commissioner may go to the concerned police station of the jurisdiction in which the godown or a storehouse is situated, and will take along 2 or 3 police officials or constables to accompany him. Now the local commissioner goes to their premises, they go down. Let's assume that he is able to find those bags of rice. Now he makes a report of it. How many bags were there? How much of an infringement material was there? Sometimes it happens that you may not find the product, but you may find the outer packaging, outer boxes, outer covers being stored there. So he will count in figures and he will make a report. Now this report he submits in court. There is a time period for that also. The court directs that this report needs to be submitted within a period of 10 or 15 days, as the Honorable Court deems fit. Now, let's go on to a point where ex parte injunction has not been granted to us. Right? There was urgency. However, the Honorable Court did not feel that the urgency is of grave nature or an infringement is happening at a larger scale or is of a very high degree. Now what happens? Then that application is treated as application for grant of temporary injunction. And for that, the next stage is the court directs both the parties, both the counsels, that is, one is the counsel for petitioner, another one is a counsel for defendant, that there would be, that you please, the court may notice to defendant, and the defendant needs to file the reply. Now, one more thing happens here is that according to Commercial Courts Act, there is a provision which makes it mandatory that once a defendant has notice that a case has been filed against him before the court, so within 30 days from the day of notice, the defendant's counsel has to file a written statement. Else, the Commercial Courts Act has made it mandatory that the court shall impose cost if more than 30 days has exceeded in filing written statement. And the total span of days or the time period given for filing written statement is 120 days, which is inclusive of these 30 days. Now, what we see is in general practice that many people do not take this provision seriously. Even many councils do not take this seriously. So what happens is that court is imposing hefty costs. The costs can even, if the case is filed before district judge rank, that is right. One more thing I would like to add on here is that suit for trademark infringement can never be filed below the rank of district judge. And when the Commercial Courts Act came into picture, when it was enforced, it has already segregated and categorized courts and giving the name of commercial divisions. And now, honorable district judges sit in those courts, and they particularly and only deal with the matters of commercial nature, including trademark infringement suits. Now, if your case needs to be filed before High Court, a respective High Court, then your jurisdiction, the pecuniary jurisdiction, needs to be of 2 crore rupees. For that, you need to file court fees of around 2 lakhs. So many people, many clients will also say that no, we cannot afford this much court fees. So you may file it before the honorable district judge. So the case is moving on, proceeding. And while filing your written statement, one has to make sure that he or she files your admission and denial statement. Now, what is admission and denial? You will be admitting some documents which were filed by the petitioner in his petition, or you may be denying the same documents. For example, I am the counsel for petitioner. I have filed my registration certificate. I have filed my journal extract. I have filed my bills, copies of bills and bills running into hundreds of pages. I have filed my status report. So you as a counsel for the defendant or the opposite party have a duty that you will file a statement of admission denial along with the written statement itself, because now it's a mandatory rule as per Commercial Courts Act that your written statement will not be taken officially on judicial record if you're not filing your admission and denial statement along with it. Now what happens is that in admission and denial, there are several columns. While denying a document of a plaintiff or a petitioner, you need to give valid reasons. Yes, you need to give valid and cogent reasons. You just can't say, I deny, I admit. No. If it's an admission, then it's fine. It needs no reason. However, if it's a denial, then it needs to be a very specific and a cogent denial. You need to give reasons why it is denied. Is it not original? It's a copied document. That is why it is denied. It's an ITR return. It's not legible. There's some technical issues in it. Why it is denied? You need to give reasons. Else the court nowadays does not accept this piece of document and will even refuse to accept and take on judicial record your written statement. So please do keep in mind all the budding litigating lawyers out there. And please do make it a point to read Commercial Courts Act, as now Your trademark infringement suit needs to follow the procedure of Civil Procedure Code as well as Commercial Codes Act. Now, what used to happen prior to enforcement of Commercial Code Act was that while filing additional documents, right, when I was filing my petition, I somehow forgot, or I somehow missed, or my client somehow missed giving me a very important document. It may be some of his bills, it may be some of his advertisements, it may be an audio clip of his advertisement, it may be an advertisement which was published in a magazine, which he forgot to give me, or at that point of time he could not get hold of because some fire broke out in his office or so, or he misplaced it for the time being. But now these documents are also important. They need to be placed before the court so as to adjudicate my matter in its totality by taking in account all the documentary evidences and all the electronic evidences which you have provided. So earlier what used to happen was there is a provision, that is Order 7 Rule 14 Clause 3 of Civil Procedure Code. We were filing this application before the Honorable Court, and we were simply stating that, Your Honor, please kindly allow this application and please take my additional documents on record. Now, at that point of time, now it's not a very long time back ago, but it's not allowed now. We used to say that please take it on record, as it may hamper the adjudication process, and it is vital for the adjudication on merits. For that also we used to give reasons. There need to be cogent reasons. It should not be a reason or an excuse merely coming out of thin air that why you haven't filed these documents at time of filing your petition. So coming back to the point, this application used to get allowed. Now what happened is the Commercial Codes Act, what it did away with this provision. It said that this provision will not apply to the suits which are filed under the category of commercial suits. Now it came up with a new provision stating that first, a leave would mean a permission has to be taken from the Honorable Court, specifying in very lucid words and language that why the court should take your additional documents on record. Well, you were not vigilant at time of filing your suit. You just slept over it. If there is not a cogent reason, there needs to be a very, very, very strong reason for the court to believe that you were bona fidely not able to file your additional documents at the time of filing your petition. If it does believe, the court allows the application, and subsequently you are given time to put these additional documents on record as well as supply the same to the opposite counsel. Right? Now moving further. Now what happens is that in a case where your temporary injunction application has been decided on merits. When I say that the application has been decided on merits, it means that the opposite party was also summoned before the court, and his or her reply was also taken on record and was considered while adjudicating your injunction application. As it is temporary in nature, it means that for the time being, let's adjudicate this application so that no more further apparent losses may be caused to the petitioner. So, supposingly, this application is decided in the petitioner's favor, the one who is the genuine registered trademark owner and a user, as well as he may or he may not be using it since a very long time. It may be a short duration of use also, and it can be a long duration of use also. Now, this application has been decided in the petitioner's favor, and order has been written in my favor. Let's suppose I am a petitioner. So it gives strength to my case because it is not the final adjudication of my case as of now. There are more procedures which are to be taken care of while we are moving ahead. So, as per Commercial Codes Act, now Commercial Codes Act was drafted with the sole purpose in mind. The very purpose of it being coming into existence was to adjudicate suits or cases of commercial nature expeditiously, right? To give them a fast pace, because the stakes are quite high in such cases. The losses which occur to business organizations run into crores and crores. And it is not, one might observe that in trademark suits, it's quite apparent and general and quite frequent that the petitioner or a party who's suffering, whose trademark is being infringed, is suffering huge financial losses because his goodwill is being misrepresented, his business is being diluted by it being taken away by some false competitor out there, right? So we were on the point that when our application for temporary injunction gets decided, we are with the order in our favor. Now, the court on its own motion, that means the court may apply its own mind after going through the case file and seeing that it appears that the defendant has indeed been copying the trademark of the petitioner, and all the documentary proofs, everything which is on judicial record in the file of petitioner points to his genuine use, and he is the owner of the trademark. I mean, it's not even contested anymore now. So the court may pass a summary judgment itself and may not go into the stage of recording evidences from both the sides, because it takes quite long to record the evidences before the court. If after deciding temporary injunction, and even if prior to deciding it, the court feels that a summary judgment needs to be passed while keeping in mind the petitioner's case as well as the defendant's case, the court may proceed with the same. Now, it's not as if the court has the power to move on its own motion to pass a summary judgment in such matters. The petitioner also has a right. He can also move an application through his counsel before the court to please adjudicate my case summarily and to pronounce a summary judgment in the matter, as all the facts, all the documents, all the evidences, be it electronic or documentary. When I say electronic, the evidences will include a recording of an advertisement, if you are running an advertisement on TV, and so on. Your recording which you had done with the help of your employee while telling him to investigate the infringement which is happening or taking place in the same marketplace. He or she may have recorded that the products bearing your similar trademark is being sold 2-3 blocks away only in the same marketplace. And that will be also covered under the ambit of electronic evidence. That all can be filed in a form of pen drive or a CD. So the court, after perusing and appreciating these evidences on record, upon filing the application by the counsel of the petitioner, may come to a conclusion that yes, I am seeing that infringement is happening and is taking place. And if sooner this infringement is not stopped or halted, then as it is in my case, I am producing rice, I am processing it and packaging it, as well as I am selling it further through vendors. So I am incurring huge losses to my business, as well as my goodwill is also being affected at a tremendous degree. So I can very well have a summary judgment in my favor. Now people, while doing this, please do keep in mind to draft your applications in very clear words. Please do support them with case laws. And please be clear with the provisions of Commercial Codes Act as far as summary judgment is concerned. Now moving on further, there is one more very vital provision in Commercial Codes Act which needs to be mandatorily complied with, is section 12A. Now what it says is that one has to go for a pre-institution mediation or settlement. This means that before filing your case, you need to file an application or a form before the Legal Services Authority stating that you would like to have a mediation or a settlement with the defendant. It is a mandatory provision. However, what happens is that in trademark infringement suits, we lawyers, what we do is we file an application for temporary injunction, which means that we are seeking and praying for urgent relief before the honorable court. So we automatically get exempted from going into pre-mediation institution and settlement proceeding, which may take about 2 to 3 months. Yes, it takes that long. So we automatically get exempted and our case is going on and on and on. One more very important factor is that please do mention everything in your pleadings. By pleadings, I mean your petition, defendant's written statement, then your rejoinder, then his replication if he is allowed to file in replication. Whatever you aver in your pleadings, please do attach a documentary or an electronic proof with your petition. Please do that. And in a case where you annex a documentary evidence or an electronic evidence behind your plaint, but you do not state it in your plaint, there is no paragraph regarding it, there is no mention of that particular detail or particular evidence, then your evidence will not be considered. Yes, people, your evidence will not be considered while adjudicating your case, and it may cause defeat to your client. Now, what I was talking about was that pleadings must mention whatever evidences you have attached or annexed. After this, the case moves on at its own pace. The Civil Procedure Code takes the dais, and the provisions of Civil Procedure Codes start working in motion. That your evidence has been taken on record, the evidentiary stage comes up, the statement comes up, and so on. Now, in a nutshell, this was the procedure which is followed as of now in commercial courts, or as you may say, in commercial divisions. And this, I say people, nobody teaches this. One has to learn after going through the grind of practicing in court. And it is not given in any book, I will assure you. Yes, trademark filing procedure can be found in books and so on, but procedure relating to the actual practice which is taking on in courts and the actual procedure adopted and what are the stages and how to overcome those stages with success and not to cause delay or harm to your client can only be understood while you are practicing and litigating in infringement matters. Now I'm being asked quite few questions which I was told by team of LicitElite to answer on this platform. So I will first read the question which has come from you people only, and I will answer them. So the first question which has been asked by some esteemed person, I must say, is that how to claim trademark for which an objection has been raised or trademark department has cancelled it. Well, sir, ma'am, whoever it is, first of all, if examiner has objected to your trademark application, then you need to remove that objection within 30 days. And if that objection is not removed 30 days, your application lapses. It is no longer in existence, and your application gets rejected at that very point. So you need to clear those objections. And even after you have filed responses regarding those objections, and the examiner is not clearing your application or not moving your application forward, then you may also apply for a show cause hearing. Yes, that means that an application is filed for appearance before the trademark registrar itself. And your counsel or you can go in person and argue your own case and explain it to them that how your trademark is distinct, different in its outward appearance, in its sound, in its color scheme. Fine. Okay, one more supplementary question was, or trademark department has cancelled it. Okay, so now what happens is cancellation application is always moved by some opposite party, someone who has shown before the registry that you are infringing their trademark. That means you have copied their trademark in their color scheme, in their outward appearance, or you have copied their the word mark itself. So if it has been cancelled, well, appeal lies to Intellectual Property Appellate Board then. Please file appeal over there. We have a body for that also. Now, moving on to the next question. One sir or ma'am has asked that If one person has not registered his trademark and is famous in certain state, and the other who is also famous with same brand in certain state, can both get a trademark in their geographical boundary? Now, whoever it is please try to understand that if your trademark is registered in India, it's binding all over India. Even if it was registered before Delhi Trademark Registry or Mumbai Trademark Registry, or for the matter of fact, Chennai Trademark Registry, it can be registered before any registry, but it is binding all over India. So if you are a prior user and you have a trademark registration certificate prior in time, and the other person who is using the same or similar trademark to you is also there, then the remedy lies before the courts. One must file a infringement suit before the court then. And there is no question of overlapping of states in this case. You can get it registered. There are 3 trademark registries as of now. You can get it registered in any of them, and their decision is binding all over India. Yes, if your trademark is registered, that certificate shows that it is valid and legitimate throughout India. Now, another question asked by one esteemed sir or ma'am was, well-known trademark and passing off, the difference. Okay. Now, dear people, what happens is that for a trademark to be well-known, I'll take an example. Let's take an example of Tata. Now, it's quite prevalent, right? The extent of its usage is quite broad. The geographical area which the business of Tata's is being covered is also broad. So that is a well-known trademark. But in order for a trademark to be declared as a well-known trademark, an application needs to be filed before the registrar of trademarks. He or she may decide it to be a well-known trademark. Now what happens is only big and very financially stable organizations go for it. Why is it so? Because the fees involved in well-known trademark application is around 1 lakh rupees. So you need to first file the fees, then you file an application before the registrar of trademark, under whose jurisdiction you get covered, right? So the examiner or the registrar will take into consideration factors such as the popularity of your brand. Now, as we all know, Tata is quite popular, right? The word mark, T-A-T-A, the way it appears is quite popular, and every second consumer or second person knows what Tata and who Tata and what it's all about. It's quite a big brand name. So the trademark registrar will consider this. Apart from it, he or she may consider that what is the expanse of area in which it is being used. So we all know Tata is being used pan-India, even in other countries too. They may be selling their equipment, they are selling their services. It's quite a big industrial name in itself. So it cannot be contested. Now, another question was passing off. So people, passing off is nowhere given in Trademarks Act. Why? Because Trademark Act states that If your trademark is registered, then only you have a remedy for filing a case for your infringement of your trademark. Passing off is nowhere mentioned. Passing off is a common law remedy. That means that it was evolved by many judicial decisions. And let's suppose your trademark is unregistered. So you can very well go for the passing off remedy. However, there are certain complications and certain conditions to it. The burden of proof is quite strong on the party who claims the passing off is taking place. Well, moving on to the further question is, this is a question which may be of interest to all the budding lawyers and new lawyers, or I may say experienced lawyers also. Can we become trademark lawyers without getting into litigation? So you can become a trademark attorney, that's for sure, without getting into litigation, because see, this field is divided into two sections. One is of trademark attorney, one is of trademark lawyer. How? In the beginning of my lecture, I was talking about how a trademark gets registered. I was just giving a brief introduction about it. Right. Filing an online application before the trademark registry, then doing a search report prior to it, so on and so on. So for this, one can easily go into, because it is sort of a desk job, preparing search reports, preparing oppositions, preparing reply to oppositions, or preparing responses to objections which are being given by examiner. This is all a desk job, and even a paralegal can do it. By stating this, I mean a person need not have a law degree to do all this. That is at a filing stage and following up with the filing. One does not need a law degree to do it. And the another part of it is the litigation part. Obviously, for that, you need a law degree. You need to get registered, and you need to have at least 2 to 3 years of hardcore litigation practice before courts in trademark or copyright matters, or in other intellectual property right matters. Furthermore, I would like to state that nowadays what I am observing is that when hearings are taking place before the trademark registrar, or an appeal is being filed to IPAB, that is Intellectual Property Appellate Board, so lawyers are only appearing. Why it happens is that because we as lawyers know how to present case laws and judgments and how to support our arguments. So nowadays firms are giving preferences to lawyers in that section and that role also. Well, another question which came up before us is how plagiarism in trademark can be avoided. So dear people, plagiarism does not happen in trademark. Infringement of trademark can happen. Plagiarism does not happen. I mean, you are copying someone's trademark and using it by sticking that particular label on your bags or whatever product or services you are having. So it's called infringement and not plagiarism. Well, the next question is, I would wrap up quickly so as to not bore all of you. Now, this question will interest many people out there, many young budding lawyers and law students. Scope of doing LLM in IPR. Well, people, please go ahead and do your masters in IPR. The scope is very wide, and it is quite beneficial both financially as well as for professional growth if one decides to practice in IPR, and if one decides to pursue a career in IPR. Please do go. It's a green signal from my end. Well, another question is, I think it's for those, someone must have asked this question who does not have a law degree as of now, and he or she has some apprehension. So let's clear it. Is it necessary to have studied IPR law in law school to have a career in IPR? Further, our CA, that are chartered accountant, company secretary, ABA students preferred by firms over art students in this field? First of all, I would like to say people that in all law schools where law is of 5 years, I suppose IPR is being taught, so that's not a big issue. Furthermore, the question relating to the fact that our CAs or CS or people from Bachelor of Business Administration degrees are preferred over art students. So this is not the case. If you wish to be a paralegal, that is, you wish to do the desk job pertaining up to these trademark applications, making search reports, filing opposition, drafting opposition, etc. You don't need a law degree. And there is no bias that you are a CA or a BBA. Last question is, how do we get opportunity to join this firm? Well, I'll assume that you mean joining our firm. Please correct me if I'm wrong, anyone. Well, if you're a lawyer, then we can get in touch, absolutely. And if you're a law student, we have internships also open. Well, as of now, COVID is going on, so we are not taking any interns. But after 2 months, we are surely opening the positions for interns too. And we are based in Delhi. Well, over to Miss Avantika Ahirwar. Avantika? Yes.
Yes, ma'am.
Yes, we are done for the day now.
Okay. Thanks a lot, ma'am, for enlightening us with your words of wisdom. Thanks a lot to all the participants for listening patiently and making this event a success. We wish you all a very great evening ahead and looking forward for your support in the upcoming events. Thanks a lot, everyone. The link for the feedback and the attendance will be shared in the chat box. Very soon. Okay, you guys can check. The link will be here in a minute. Yeah, the link is here.
Well, thank you so much, people, and all the best for your future endeavors. And I hope you all become very good lawyers. And if you're already a lawyer, you prosper a lot. Thank you so much.
Thank you so much, ma'am. Thank you.
Okay. Thank you.